We are now recording, and I'm going to turn it over to Attorney Spada and Judge Williamson.
Thank you, Lori. Good afternoon, everyone. And thank you for spending your lunch hour with us this afternoon as we start to talk about all things adoption, practice, and procedure. I have the pleasure of presenting today with one of our esteemed members of the bench, Judge Williamson. So welcome, Judge Williamson, and thank you for taking the time today to present with us.
Thank you. Thank you, everybody, for being here.
So given that we do have an hour for this presentation, I would say that we're going to ask if you have any questions throughout to just drop them in the chat box. We will monitor that and see if we can answer questions throughout the presentation. But we will try to leave a few minutes at the end for any questions that were not answered during the presentation. And just so I have an idea, how many participants actually regularly practice in the adoption area? Just show of hands. Okay, so a handful of people. You may or may not agree with me, but I sometimes feel that there is this misconception out there that adoption cases sometimes are very easy, straightforward, and just the very happy cases that we take to court. And while it's so fulfilling to help clients build their families through adoption, unfortunately, there can be significant pitfalls if you are not familiar with the procedural requirements that are out there. And as our appellate cases or our appellate courts continue to remind us, especially in some recent cases that have come down, these cases require a strict compliance with the statute and the rules. So we have to be mindful of both of those as we walk through any adoption case. And right off the bat, I would say you want to have a clear knowledge of all of the statutes and rules and the case law that applies to these. There's a lot of case law out there around termination of parental rights and even adoption. And in addition to that, just starting off, you want to have a clear picture of who you actually represent. And I think that's important, who your client is, who is not your client. So if you are representing, let's say, prospective adoptive parents, what, if any, contact can you have with a birth parent? Where do you draw the line in any contact with a birth parent? Where are any conflicts of interest that might arise in representation of prospective adoptive parents? Let's say that are, if you're jointly representing spouses, what duties will you have and to whom during your representation, and what duties might you have in the future? So it has us to kind of step back and remind us ourselves of the rules of professional conduct as well. So we're practicing in an ethical manner, and also a good working knowledge of the law around attorney-client privilege. With that, the statutes that we want to be concerned about in Pennsylvania, because we are talking today about domestic adoptions only, we're not going to touch on international adoptions, and we are not going to get into those cases that implement the interstate compact. So those cases where you have parties in different states, that we could probably spend an entire hour, if not an entire day on some of those cases. So we're going to stick to domestic adoptions today. So the statutes that I'm sure we have to be familiar with are the Adoption Act, right? The Child Protective Services Law. So those of you that are practicing an adoption, or if you don't regularly practice an adoption, any prospective adoptive parents have to submit clearances to the court prior to the final hearing. And that statutory requirement comes from the Child Protective Services Law, that everyone has to have both their FBI clearances, their state criminal, and also their child line clearances. In addition to the Adoption Act and the CPSL, we have to be concerned with our rules, not only the state orphans court rules, but also the local orphans court rules. So in your packet of materials today, it's handout number 3. We did provide a copy of the Monroe County local orphans court rules, and we'll refer to some of them throughout the presentation, but obviously read through them and familiarize yourself with them. With the Adoption Act, I will say, if you read it very carefully, it is your roadmap for any adoption proceeding, but it does require a very careful reading of the statute. And so one of the first sections, for example, that you'll come across is section 2312, which tells you who can actually be an adopting parent. And it very simply states that any individual may become an adopting parent. But in my firm, my colleague, Craig Bluestein, he likes to sort of say that's very true. Any individual can become an adopting parent unless they can't because there's another statutory section that precludes them. So we need to read the fine print. It seems pretty straightforward, but there are a lot of nuances in that particular statute that you need to be familiar with, especially knowing what the evidentiary standard is right off the bat as you start to prepare your cases. So you have a clear picture of what you have to prove right from the beginning. The evidentiary standard in these cases is clear and convincing evidence for termination matters, which is, as we all know, the highest evidentiary standard in our civil cases. And as we proceed through the two-step process of termination, or in an adoption process, which is termination and finalization, there are some similarities and key differences depending on you were bringing. So are you involved in an adoption where, let's say, care and custody of the child? Or are you working with a private adoption agency who potentially is the intermediary and facilitating the adoption? Or are you just working with the prospective adoptive parents who have facilitated a private adoption between the birth parents? And so in Monroe County, there's actually a specific procedure for termination and finalization, but I'll turn it over to Judge Williamson now to talk about those cases where the county agency is involved and termination might have already occurred, to talk about how that procedure goes.
Thank you, Attorney Spada. So, generally you want to be familiar with the requirements of section 2501, 2701, and 2901. But where you have an agency who has already obtained termination of parental rights through court order, the adoptions that come out of that sometimes are done in the same county where the TPR was granted, and sometimes they're done in other counties where the parties are residing. We keep in mind the venue statute under section 2302 because, as I said, it doesn't necessarily have to be in the same county where the TPR was granted. If TPR was granted an agency case, children and youth has been involved, courts entered a final order of termination, there's been no appeal or appeal rights are exhausted. Under section 2302, venue is specifically allowed in the county where the adoptive parents may reside, and oftentimes that's a different county than where the TPR took place. Where the agency that had custody or the agency that's placing the child for adoption is located. So again, that could be back in the county where the TPR was entered, or where if there's leave of court, you can also do it in the county where the adoptee formerly resided, where the child formerly resided. Keep in mind there are still consents required in those cases where TPR has already been entered. Reports are required. Be familiar with those statutory sections there. Generally, section 2530 to 2533 and sections 2711 to 2714. In our county, I've heard adoptions where TPR is entered from children and youth from other counties, and also where the child and family and court were all involved here in this county. We all have the COVID situation that has changed the way of things were done in the last year. We're coming out of that now. We really are not allowed to do anything by video anymore that's not specifically authorized by statute, unless generally you have all the parties in agreement. So I'll let you know that going forward with adoption hearings only, where there's already been TPR entered, or perhaps it's an adult adoption, I will continue to do this by video if the parties want to do that, if it's easier than coming into court. But if they want to come into court and have it live in the courtroom, that's fine too. So it's just a matter of counsel let me know, either by motion or call in to let us know how you would like to have that hearing. Again, that's only when TPR has already been entered previously, or perhaps you're in the situation of adult adoption.
Judge Williamson, do you want to talk about, since you mentioned adult adoptions, just generally that procedure,
Sure.
since it's a pretty straightforward, I would say.
It is, yeah. Short part of our conversation here today, really. If you look at the statute, if you haven't had an adult adoption before, if you look at the statute at 23, section 2311, it defines who may be adopted. And much like who may adopt, who may be adopted is the same. It's anyone. It doesn't give an age parameter. It doesn't say how the person needs to be related in any way. Anyone can be adopted. Adult adoptions are typically done, that I see, by step parents, perhaps during the child's younger years before they were an adult. The family just didn't want to pursue it. They didn't want to terminate rights of a parent. But later in life, the child and the step parent have decided they want to have that formal parent relationship. That's the one we see the most of. When those come in, I schedule them as soon as possible, just try and get them done for the families. And again, like I said, I do it by video if it's easier for the parties, because there's really nobody who's going to participate probably that's going to object to that other than the parties themselves. But do be prepared to go over with your clients what it means to be adopted as an adult. There are still questions of inheritance rights and so forth that you want to make sure your clients understand. And I prefer that be placed on the record, that they understand that what they're doing by agreeing to the adoption. So I think that covers enough on the adult adoptions.
Okay. I actually just had one other question for you, Judge, with respect to the adult adoptions. I know you mentioned that there probably won't be anyone there at the hearing to object, but is notice required of the birth parents for the adult adoptee?
No, and a big difference on the adult adoptions. And that's maybe why people wait too, until they're adults to do that and don't do it when they're minors. No requirement of notice, no requirement of terminating rights. There's really no one to come in and object to the proceeding. It's just a question, does somebody want to adopt someone who's an adult? The parties come in and place that on the record. Law instructs us to do so.
Understood. And don't forget that the adult adoptee is obviously over the age of 12, so the statute also requires them to have that written consent that they are in agreement with the adoption, as well as placing what Judge Williamson said on the record, certainly about the responsibilities and duties, perhaps later in life, to the parent that is adopting. Okay, great. So if you have not had to do the heavy lifting of termination, because the agency might have done that and you're stepping in as the for the final adoption hearing, the other cases that we'll see are the private cases, right? So that we have the two main phases, which include, as I mentioned before, terminating parental rights and then the finalization hearing. How is termination done? It could be done a number of ways, whether it's voluntarily or involuntarily. We did put together a handout, number 1, in your materials, which outlines, or I should say summarizes, the options for voluntary relinquishment, and also includes a lot of sample forms for you in there as well. So if a birth parent is voluntarily relinquishing their parental rights, there are two options. It could be a birth parent petition that they are filing with the court, or a signed consent by the birth parent. And Judge Williamson, would you agree that probably the county sees more of the second option, really the birth parent signed consent?
That's true, yes.
And the particular requirements of the consent, we outlined the statutory sections, but you want to look at sections 2504 and section 2711 of the statute. 2711 very clearly outlines what is required in a birth parent's consent. And certainly you want to make sure you're following what those are so you don't have any issues by the time you get before Judge Williamson, certainly. But a birth parent does generally have 30 days to change their mind and revoke that consent in writing as of the date of the signing of the consent. Okay, certainly a birth father has the option to sign earlier, and it's outlined in the handout what those time periods are. But generally after signing the consent, after the child is born, a parent has 30 days to revoke those consents. There is the further timeline of 60 days to challenge based on fraud or duress. I will say in the 12 years that I've been doing this, I have maybe seen that challenge once. I don't know, Judge Williamson, does that come up ever, or have you handled cases of birth
No, I
parents
have not. I've not
challenging?
had that come up in 10 years on the bench. No, and not in private practice either.
Okay. So generally, wait those 30 days, file your petitions to confirm consent. It still requires that the petition be filed to confirm the consent, although different than if the birth parent were to petition the court. The birth parent doesn't actually have to attend the hearing, but I would say preferable if possible. Would you agree, Judge?
I would. I mean, you have to provide them with notice anyway. It's preferable that they're there just to confirm also on the record. But it's, as you said, it's not necessarily required. So do the best you can.
And there are witnesses that are required to sign, verifying that the birth parent has signed off on the consent. In some counties around the area, they require notarization as well. Judge Williamson, what's the preference of the court? Is a notary helpful, or are the witnesses enough?
The witnesses are enough. I mean, to me, the notarization is important if you think somebody's going to contest it later. I mean, it's just an extra layer of certainty that the person actually signed the document, but I don't require it.
And do you require any testimony from any of the witnesses who signed the consent?
Not unless there's somebody shows up to challenge that they didn't sign it or they didn't know what they were doing. And I'm not sure I've had that happen. So.
So if a birth parent is not going to voluntarily relinquish their parental rights, there may be grounds to involuntarily terminate their rights. In that handout, we also included all of the grounds that are currently outlined in the statute. And right now there are 11 grounds that are out there that you can allege to terminate parental rights. I would say what I see most often in private cases are 2511A1, which is the lack of continuing contact from a parent for at least 6 months preceding the filing of the petition. 2511A2, which is the repeated and continued incapacity, neglect, or refusal of the parent. But an important piece there is that has to be proven that that conduct continues in the future. And also 2511A6, which is a 4-month ground for a newborn child where a parent has not provided any sort of parental care to the child in that time frame. When you are putting forth a petition to involuntarily terminate parental rights, you do want to very specifically outline which grounds you are alleging in that petition. And do not forget, I see this sometimes in petitions, do not forget to allege the important ground of 2511B, the needs and welfare analysis for the child, and include certain factual allegations about why this adoption meets the needs and welfare of the child as well. Because there are that 2-step analysis in involuntary terminations, both 2511A and 2511B, and you have to meet both by clear and convincing evidence. If it's not in there, I have definitely seen trial courts deny terminations and also appellate courts reverse, specifically because there might not have been sufficient evidence on the 2511B subsection. Now, typically it is, if you practice anywhere other than Monroe County, you might see 2 separate hearings with respect to the involuntary termination process. But Judge, do you want to talk about how it's handled here in Monroe? Because it is very much different, and what you want to see
Sure.
when it comes to a hearing.
Sure. And this really goes back, I think, even to when Judge Marsh was taking care of TPR and adoption hearings, certainly continued through Judge O'Brien, Judge Miller, and now myself. And that is that we'll accept and prefer that a petition for adoption, and well, you have to file your petition for adoption at the same time you're filing your TPR, because if there's not an adoption anticipated, TPR is not going to be granted. So the petitions come in the same time. I will schedule them for the same time at hearing. And in the event that TPR is entered by the court, we do not require you to come back for a second hearing on the adoption grounds. Rather, you can have those grounds and should place those grounds on the record, the facts that support that adoption petition at the same time. Sometimes counsel even says, "Is it okay, Judge, now if I go into the facts that support the adoption petition?" And that is fine. You also don't have to ask me. You can just go directly into it, but be prepared to cover that. That way, I think it's I think it's easier for the family that they don't have to come back a second time, particularly where perhaps the children are young and at an age they don't even really understand what's going on, or don't realize that the person adopting them isn't already their parent. Yes, it's a happy day when you do an adoption, but involuntary terminations are never happy. And I don't think, especially young kids, don't need to be coming back to court. So there's different reasons, I think, why all the judges in this jurisdiction have done it that way. Those are sort of some of mine. There's also the "it's not broke, we don't need to fix it" attitude, but I have my own personal reasons, and I just think it's better for everybody involved, and we don't need to spend the time to do that a second time. So that's what you can expect when you come in, that I will take testimony for both. Obviously, if I don't grant the TPR, testimony is on the record about the adoption, but it hasn't hurt anyone to put it on, especially when really it only takes 10 or 15 minutes to do so.
And how does the procedure differ, if any, if there is, let's say, an appeal of a decision of Your Honor terminating
Okay.
parental rights? Should let's say that appeal is upheld and eventually we get the record remanded, does the petitioner need to file a motion for, the final decree to be entered, or will that automatically happen after the record is remanded?
Yeah, we automatically track it. We put it on our calendar. If there's no appeal filed within 30 days, we'll go ahead and automatically enter the adoption decree. We will have asked and expected counsel to let us know at the time of the TPR hearing that if there's a name change that's wanted, and then we will put that in the adoption decree. If there's an appeal, and there's a final determination following that appeal that upholds the finding of a TPR, again, we'll have it calendared. We'll take care of it. If you don't see an order from us within 7 days or so after either an appeal is final or the 30-day time period, if no appeal has been filed, is up, call into chambers. Maybe we just overlooked it on the calendar, but we will track that. There's really no need to file a motion to do that separately at a later time.
Okay. And what about the scenario that notice is given and let's say a birth parent arrives at the hearing without counsel, but requests counsel?
So I think everybody may be aware now through court cases that have been handed down that it is a legal right, even in a private TPR. I mean, it's set up in the statute on the agency TPRs for counsel to be provided, but by same token, on private TPR petitions, the parent whose rights are sought to be terminated has an absolute right to legal counsel. So does the child in an involuntary TPR. So when my order comes out, I always appoint someone immediately to be counsel for the child. And they'll represent that child throughout the proceeding. Not a best interest standard. They are legal counsel for the child and what the child wants, if the child can express that. Parents have an absolute right to legal counsel as well. And I will put in my scheduling order that they have that right to legal counsel, that if they cannot afford legal counsel, they're to contact court administration, who will require them to file something. At the very least, call them to see what they need to do, but they'll be required to file something to request legal counsel. It's rare that somebody does that prior to a hearing, but if they've alleged enough in the petition that they can't afford legal counsel, I will generally just appoint it for them at that point. But if they don't do anything and they show up at the hearing, I will specifically ask them, do they want legal counsel? Do they understand their right to legal counsel? If they want additional time to retain legal counsel, I'll continue the hearing, allow them to do that. But it's anticipated they will come back with legal counsel, or they'll end up being pro se. Or if they request legal counsel, they say they can't afford legal counsel, I'll just walk them through a couple questions that I feel is enough to show me they can't afford legal counsel. And if that showing is made on those questions, I'll grant the request. I'll continue the hearing date, appoint counsel that the county pays for, and we'll come back at a later date. Attorneys can ask questions if they want to about the ability to pay legal counsel, but I won't let them get too far with it. And most likely it's not going to change my mind if I've already found there's enough to grant that. I'm not going to deprive anybody the right of legal counsel, and one, not give them an opportunity on something that's very important in their life, but also secondly, we don't need to have the matter reversed later just because legal counsel was not appointed. And the Superior Court, who will tend at times to maybe jump in where they shouldn't on factual findings, says that person should not have been afforded legal, or should have been afforded legal counsel when you didn't. Then we got to bring everybody back a second time and do it all over again. And that's not something I want to see happen. I don't care about getting reversed. I just don't want to put the family through it again.
Yeah.
So,
I'd rather go to Shake Shack if we're gonna eat. But I'm fine right now.
I want to just
All right.
remind everyone.
who
if
wants to
you're
join
not-
Attorney Merwine at Shake Shack? Go ahead, Attorney Spada.
Thank you, Judge. You mentioned counsel for children, and that has been a pretty hot topic in termination of parental rights and adoption matters. Over the last couple of years, I would say there's been a lot of cases that have come out around that. Would you ever have reason to interview the child yourself, even with counsel appointed, and how would you handle that?
Talking to a child is a case-by-case basis. Generally under 5 or 6 years old, I really don't see a benefit to talking to the child unless it's really specific to an issue. If it's just generally because the child's here and wants to say hello, or parents think the child wants to say they want to be adopted, that generally isn't enough. But if there really is something important to the case, the child can tell me, and they're 5 or 6 or younger, then okay. If not, I really would expect if the child's going to testify, they're going to be older, and they have some particularly strong feelings about something, and maybe it's a close call in the case. Again, prefer not to have children testify, but certainly they are allowed to. And if their counsel thinks it's very important, they should bring it to my attention and I'll hear from them. I think everybody knows my policy. It's the same. I think that all the judges in Monroe County do, and that is we clear the courtroom except for legal counsel and the child and talk to them. I generally don't bring back to my office because you got to walk down the hallway, especially with COVID, not a lot of room here to do that. So generally I do, the question and answer right in the courtroom. And again, with COVID, I don't usually come around close to the child. I stay up on the bench. But if we get out of COVID, I try to be down, sitting at a table or in a chair closer to the child and have a little bit more informal conversation.
And I will say we did include handout number 2, a number of cases that we thought were particularly interesting. There's been some discussion by the appellate courts, or I would say cases by the appellate courts, talking about, what cognizable adoptions are, and what is appropriate for a trial court to grant an adoption, and where certain circumstances that are not. I do want to note one particular case that I did not include in the materials because it came out just very recently, August 19th. It's in re-adoption of KMD, and the site is 2021 PA Super 168. If you missed that, just send me a chat and I can send the site to you. But it does talk about what I mentioned earlier, the strict compliance with the statute. And in that particular case, it talks about service requirements. So the statute outlines that notice to parents in an involuntary proceeding needs to be done by personal service or by registered or certified mail. And Judge Williamson, I don't know what you've seen or what your requirements are. So is personal service what is the gold standard, or what do you like to see?
Yeah, it is. It is. Just a comment on the KMJ case. I think that was the case where they tried to set up by Zoom and the notices did not go out to parents. Was that the same case I'm thinking of?
This one, they tried to send notice by email.
Yes, and I think because it was an electronic hearing by Zoom,
Yes.
and right, it was tried to be sent by email and potentially by the invites that you do by Zoom. That's a whole other problematic thing that I think took place during the COVID pandemic, and hopefully that's the reason it happened, and that isn't going to continue to happen. Yeah, it should be by personal service. And I would expect everybody would attempt personal service regardless of where the person resides, whether it is in Pennsylvania or somewhere else. And if the person cannot be located or it's a difficulty in getting that person personally served, then I would expect, like you do in any other civil case, you motion for alternative service. And then I'll require it to be advertised generally in the local paper and legal reporter. And if you have a location in another jurisdiction, in that jurisdiction's publication as well. I've had ones where it's out of the country. I think I have attorneys on here today that have been able to manage to track people down in other countries and actually get them served, despite you think it being an impossibility. It's not. I'll just extend hearings out to get that done. I think it's important that parents have notice in their hand of the paperwork that's filed in the hearing date, because there's no easier grounds for appeal and reversal than somebody coming in 6 months later, 2 years later, doesn't matter, they haven't seen the child, may get reversed and come back and do it all over again. So yes, I would want to see personal service and any action taken where that's not possible. Then you'd follow up with a motion for alternative service.
And I will say that is exactly what this case did. There was an argument about whether or not the parents had, quote, actual knowledge of the hearing, and that to the Superior Court was not enough. There was some testimony that they might have known about it, but as Judge Williamson said, it wasn't clear that they had the documents in hand, the petition in hand, and full knowledge of it. And they were even represented by attorneys at that point in time as well, who had some contact with the parents. So it definitely is better to comply with the procedural rules, certainly, than to have to deal with a reversal or a decree being vacated later on. Some of what I mentioned earlier about cognizable adoptions, Judge Williamson, I want to talk about certain situations. So let's say a step parent or a de facto step parent situation. Let's say you have a birth parent who is seeking to terminate the other birth parent's parental rights and have their partner, fiance, adopt the child, and they are seeking to retain their parental rights. Is there anything that, one, should be pled in the petition that you would like to see before it comes to you? And two, what should be presented at the hearing if, let's say, a parent wants to retain their parental rights, but they're not married to their partner?
Sure. So, for the longest time, the legislatures had the statutes set up that if you're only seeking an involuntary termination of one parent's rights, the other parent is retaining their rights, then the person who's adopting needs to be a step parent, needs to be married to the parent who's retaining their rights. That was upheld, and there was case law on that in several cases for years and years. And then the case came down of adoption, RBF and RCF in 2002, which essentially was a same-sex partner case prior to the recognition of same-sex marriage in Pennsylvania. And what has come out of that case is that there should be a case-by-case analysis of where there are times that the adoption statute cannot be met strictly. Then the court may have some discretion to find that need not be strictly enforced. And again, we're still talking specifically as to who may adopt where a single or one parent is still retaining their rights and you're just seeking to terminate the other parent's rights. My reading of that case, was that the same-sex partners did not have the ability to be married as a step parent would in a formerly traditional marriage, because there's no recognition of same-sex marriage. And so therefore, the court allowed going around the adoption statute and finding good cause why it couldn't be met, and allowed the termination and the eventual adoption. Of course, now we have a recognition of same-sex marriages in Pennsylvania, so I'm not sure how the court would look at it if it was in front of them at this time on the same exact circumstances. But I think what we're looking at as far as non-married couples, somebody in a step-parent role wants to adopt, but they are not legally married to the person with whom they will both be having parental rights, then it's going to be a case-by-case basis, and a court has to determine if there's good cause not to meet that statutory requirement. There's been a couple cases since then, specifically a case that says a grandparent cannot adopt with the mother who is keeping her parental rights. You can all read that case. I don't have the site right in front of me, but it might be in the materials.
It is, and that's adoption of MRD. And I think, Your Honor, you mentioned that you're sort of not sure how the court will decide now that same-sex couples can marry, because I think for the longest time, RBF was that case out there that sort of said, we're allowed to maybe not comply with the statutory requirements. And there is this sort of carve-out exception for cause. And if you're not familiar with that statutory section, it's section 2901. 2903 says that a parent can retain their parental rights if their spouse is adopting. So that sort of gives us the what we're talking about, that it requires marriage because of the term spouse. But then we have this carve out in section 2901 that allows trial courts to dispense with certain statutory requirements if cause is there. So MRD, there was this very interesting scenario that a mother wanted to try and terminate the parental rights of a birth father who wasn't absent in the child's life, but she did not have anyone that was really stepping in a sort of horizontal type of relationship to her. So she asked her, the child's maternal grandfather, to adopt. And the court said, this creates some sort of very confusing relationships for the child, because the maternal grandfather was married to maternal grandmother. They lived separate and apart from the child and the mother. And so the court said, really, maternal grandfather is going to stay in his role as maternal grandfather and continue to support the child as he has continued throughout his entire life. And that's not a situation that we want to bend the requirements of the statute to sort of make that adoption cognizable. I will say one of the other cases in the material came out recently as well this past year, is from the Supreme Court, the adoption of CM. It was, they discussed MRD, and the situation in CM was a birth mother voluntarily relinquished her parental rights and joined a petition to terminate the father's parental rights. And the proposed adoptive parents were the maternal and maternal grandparents. And so it would appear on its surface that that is a cognizable adoption, right? You would have termination of both parents' rights. One, mother voluntarily relinquishing her parental rights, and the trial court in that case did involuntarily terminate father's parental rights, making way for both maternal grandparents to adopt. They were both married, they lived together, but it was challenged by birth father. And when it went up to the Superior Court reversed and stated that there's no new family unit that's being created in this adoption. And one of the factors that they cited was that the mother would be remaining in the home with maternal grandparents. So the court said, you're really, even though mom has voluntarily relinquished her parental rights, she's still going to act as mom because she's still living in the home with maternal grandparents and child. And they had some concern about the fact that father had filed for custody earlier. And was this in some sort of way to get around father petitioning to file for custody? Is this proper? I think it just didn't sit well with the court, because on the surface, it met all the statutory requirements. And the Supreme Court actually reversed on sufficiency grounds, but it was a very interesting discussion in the case about MRD and kind of how families design themselves a bit. This concept of a new family unit is not in the statute, but it is now in case law. So as we mentioned in the beginning, familiarize yourself with some of the case law around it, because you would think that that would be an adoption that would not have been overturned, but it was, certainly. And Judge Williamson, there is another case that we had put in the materials, CJA, which is actually a Superior Court case. It makes mention to the topic that you brought up that we discussed about marriage, but it also discusses counsel for the child. Do you want to share any thoughts on that particular case for the audience?
I would if I had it in front of me. I'm not even sure which case that is. So I apologize. And I was thinking that I really hadn't answered the previous question about scenarios coming before me where parties are not married and true step parent. And I saw something come up on the screen. Also, there was a question about, can there be an involuntary termination petition without an adoption being filed or requested? So, and these are things that we were going to cover, and I just want to make sure we cover them. So I guess I'll backtrack for a minute, then we can talk about CJ if that's okay. The backtrack is, I've had a grandparent with a mother still to retain her parental rights request. I denied it along the lines of the case we just discussed for similar reasons to what the Superior Court had said. I've had requests where a parent is in a step-parent relationship, but they're not married. I need to hear why they can't meet the statute. And what I mean by that is, why can't they be married? There's not the impediment of same-sex marriage anymore to say we can't legally get married. In a step-parent male-female relationship, it's the same thing. You can get married. What's the reason you can't meet the statute? And I've had different reasons. I'm not going to comment which ones are going to be enough for me and which ones aren't. It's a case-by-case basis. But I think there needs to be some allegation there and facts followed up of why they can't be married. Maybe it's because they can't afford it because it affects their health insurance, or you would think not, but maybe there's some other reason that they just can't be married because it's a financial impediment. That's something that I would need to hear. It can't just be because, well, we haven't felt like it yet, or we don't believe in marriage, or, to me, the statute's a statute and you got to follow it unless there's a really good reason why you can't. So be prepared to do that. And I think that's enough on that. With the petition for involuntary termination without an adoption contemplated, no, the statute does not allow for that, except in an agency, children and youth termination. Then you do not have to have an immediate adoption contemplated, but in a private TPR, you do. Now, the reason I mention that as something we definitely need to discuss is because that isn't necessarily true in the eyes of the appellate court, depending on a very fact-specific issues. I had a case where a case was appealed to Superior Court. I had denied on the sole reason that they were not contemplating an adoption. It was just a straight TPR. A mother is requesting the father's rights be terminated. It was a very awful fact-specific case. The father of the children was actually the father of the mother. He had gotten his daughter pregnant in another state when she was under the age of 18, held her captive apparently for years, fathered several children with her. Eventually it was discovered. She was rescued. The kids were rescued. The father was convicted and sits in jail in Michigan. The mother, through help of an organization in Philly, filed, I guess apparently now lives in the Monroe County area, filed to terminate the father's parental rights, even though he's never getting out of jail, he's never going to talk or see these kids, but was doing so without a contemplated adoption, just to terminate his rights. I followed the statute, went up to Superior Court. It's an unpublished decision, but it's there for anybody who wants to go read it. Basically, for any reason they could possibly find, because policy wise, I guess you certainly would not want to have these kids linked to their father if in this situation. Overturned it and sent it back. So there's no published appellate court decision on it, but I just want to throw that out there as something that you wouldn't necessarily think about, where possibly you could terminate rights without having an adoption contemplated.
And that's when, after reading that case, the appellate court used that 2901 cause exception to sort of dispense with the statutory requirement that an adoption be contemplated. It was a very interesting case read. So if anyone wants the unpublished case, certainly reach out and we can provide it to you. But there's only one other circumstance that the Adoption Act says you do not have to have a contemplated adoption. And if you would look to sections 2512B and section 2514. And those sections indicate that when a petitioner is alleging the ground 2511A7, which is when a parent is the father of a child conceived as a result of rape or incest, that you do not actually have to put forth to the court that there is an adoption contemplated. I've seen that statutory section probably once in my career, and that was before the section was amended to include that an adoption does not have to be contemplated. So I've actually never seen adoption go through, except for, like I said, the one that Judge Williamson mentioned, the unpublished case, where there wasn't one contemplated. And I would say even in agency adoptions, it's preferred, and that there be an adoption, a prospective adopted family identified for the child.
Yeah, that's a good point. I can say from locally here in Monroe County, my position, and I think Judge Mark is similar, although I don't want to speak for him, on children and youth terminations. And I don't want to speak for Attorney Dan Higgins or Judge Dan Higgins, who's doing them now either. But my feeling in that is, agency has to show really strong grounds why they're seeking a termination without an adoption. To me, it's why are you doing it then? And maybe it's because the child just wants it. Child's old enough to cut it off, but really would think that if you're going to file for termination, even through the agency, if there is an adoption contemplated, that's preferable.
And we are getting a little low on time. We have a few minutes left, and we have been able to answer questions throughout. So if you have any questions, please put them in the chat box now so we can try to take care of them before the end. But as I mentioned, in handout number 1, we included a lot of different sample forms for you. But the usual forms that obviously occur in any adoption proceeding, the report of intent to adopt, followed by the home study. The report of intent actually triggers the requirement for the home study. And as we mentioned, check the local rules, because Monroe Rule 15.2 actually states that the home study actually has to be filed within 6 months of the report of intent being filed. I'm not sure what the result might be if it's not filed within 6 months, or if the court allows any extension of that time period. Judge Williamson, I don't know if you want to comment on that.
I would allow it. I mean, generally I allow extensions as long as somebody moves for it in order to see that things happen.
And be aware that a report of intent and home study is not required in all adoption proceedings. If there is, as we mentioned, a relative, a step parent, grandparent, aunt, uncle, or if the adoptive parents are the brother and sister of the adoptee, certainly a report and home study is not required. But in any other circumstance, it would be, unless, of course, you can provide the court with cause under that all important 2901 section that we've been talking about. Other than that, you want to have your petitions, as Judge Williamson mentioned earlier, both the petitions for termination and the petition for adoption filed ahead of time, including with that the statute requires that you notify birth parents and birth relatives really of the option for continuing contact after an adoption. That is a voluntary option for continued contact, but you have to provide notice. There's a sample Act 101 notice in the materials that you can send off to birth parents. It defines what a birth relative is and some of the options for contact. So it could be as little contact or as much contact as the parties want to agree to. But again, it is completely voluntary. If, let's say, the birth parent wants continued contact, but the adoptive parents do not, then unfortunately, there is not a contract that can be proposed to the court, because it does have to be voluntary on all sides. I will say that with post-adoption contact agreements, again, there is a local rule. I'm looking for it. Give me 1 second. 15.4 of the Monroe local rules that say that when the post-adoption contact agreement, if it's in place in your adoption, it has to be filed with the petition for adoption or at the time of the hearing, because the agreement does have to be approved prior to the adoption decree being entered. Okay. And I would say if there is a post-adoption contact agreement that's being contemplated, you have to be very cautious about how that is discussed, when it is discussed, why it's being implemented, especially if you have a birth parent that is voluntarily relinquishing their parental rights or consenting. You do not want to have any sort of suggestion that they are signing a consent to adoption because they are going to have continuing contact, because we know from the statute as well that consents cannot be conditioned on any promises. So you don't want that to arise. And I've seen sometimes those come up if a birth parent wants to later challenge their consent. There have been instances where perhaps the signing of the consent was connected to a discussion about continuing contact, and that can be challenging, I think. I don't know if you've seen any of those type of scenarios, Judge Williamson, before you.
No, I mean, I think they've gone well and they've gone the right way. We don't get many of them to begin with, but I haven't had a problem with it. No. And yeah, I know we just have a couple minutes, but the CGA case, is that counsel for the child making sure that they've gotten the child's wishes on the record and that the child may or may not understand the proceedings and able to do that? Yeah. So, okay. So yeah, that comes up sometimes. The CGA case speaks to counsel, and this is a situation of involuntary termination, privately filed, and I appoint counsel for a child. Counsel does need to ascertain from the child, regardless, how old they are, do they really understand the proceedings? Because they'll have to be able to represent to the court. Child does not understand the proceedings, try to discuss it with them, too young, maybe intellectually challenged, whatever, and be prepared to place that on the record. But that if the child is able to express something, that they express those wishes on the record and or have the child testify about it. If there's anything else you want to cover on that, Attorney Spada?
No, I don't think so. I think it's pretty clear. And, in any of this that we've talked about, it's very much making your record in the adoption proceedings too. And a reminder, it's both putting on the information for the termination as well as the adoption, any testimony for the adoption as well. And when in doubt, put it on the record, because if there is an appeal, you definitely do not want to be before a particular panel that's doesn't feel like the proper information was included or presented, and then be overturned on appeal and have to deal with that again for your clients. So we have about 1 minute left. Are there any questions that we might not have covered that you have? Okay. Hearing none, I'm sure that we could continue to talk about this topic for the rest of the afternoon. But if you have any questions moving forward, please feel free to reach out. I know at least one person asked for a copy of the case law that we talked about, but if you want any of the cases that we discussed, or just let us know, reach out. Thank you very much.
Thank you, Attorney Spada.
Thanks so much. Thank you both so much for your time. And just remember, please return your attendance form to me as soon as possible. I try and log them up with the PCAL site within 2 days or so that you can see your credit. And with that, I'm going to end the recording. And I hope everyone has a great day.
All right. Thank you, Lori.
Thank you. Take care.
Thank you.
Thank you.